This is 24 SC 003048. State
Your
of
Honor.
Georgia versus Kashawn Patterson. Yeah. All right, I'll make sure.
We're gonna see. We're gonna have a seat. Okay, without it, everyone there.
So, Mr. Norman, am I correct? There's 3 motions pending?
There are 3 motions pending. I believe we have stipulations on 2 and an agreement on the 3rd. Just for the record, I filed a motion to sever the offenses. Mr. Patterson is charged for incidents on 2 different dates, a January date and an April date. And I believe my understanding, I don't want to speak for the state, but we've agreed to stipulate that we can sever the January offense from the April offense.
Yes, good morning, Your Honor. The state does not oppose the motion for severance. And because of that, Your Honor, when these cases, if these cases are severance, there is the second motion is to bifurcate the possession of firearm by convicted felon charge. By law, we will also agree to bifurcate that charge.
Okay.
So we can file orders regarding those cases. And the 3rd motion I filed was regarding if Mr. Patterson chooses to testify, his record being not being able to bring up his prior criminal history.
404B, yeah.
Yeah, and so I would, in talking to the state, what I'd like to do is wait until the beginning of my case, and then we can deal with that motion if he is in fact choosing to testify.
All right.
And then I believe Mr. Patterson filed a motion on his own. I am not joining in that motion. And I guess he can address the court regarding that if you'd like to hear from him regarding the motion that he filed.
I got it. Yeah, okay. All right, come on up, sir. Are you familiar, the state familiar with this one?
Oh, sorry.
Are you familiar with this one?
I am familiar
Okay,
with it.
all right, so this is a motion to remove counsel.
Yes, ma'am.
Alleged misconduct and ineffective assistance of counsel. All right, Mr. Patterson.
Yes, ma'am. I'm having, me and my lawyer having irreconcilable differences, and I had stated a claim for which relief could be granted. The last judge, well, Judge Schwal said I couldn't get rid of him, so the next action I can undertake now is to write the Bar Association to force him to withdraw. He's not helping me in the manner of which he should be. This case never went this far, you know what I'm saying? He never even put in for evidentiary hearing. They have nothing, all I have is statements and accusations this far. I have nothing else. I even have the 911 call to the body cam footage. It's the actual nature of the call. You know what I'm saying? And this is some of the things that I've been feeling like they've been obstructing evidence. The same thing with the phone calls and all that stuff. I asked him to let me listen to the phone calls. He brought me a packet where the victim is saying, I never said that, you know, she's denying this. The district attorney know these things. They keep, nothing ain't going. I just don't want this lawyer no more because he's not doing what he's supposed to do. So now it's becoming an appellate issue. I don't need him on my case.
So
I ask that you please grant relief
So-
by removing him.
If I may, Your Honor.
Sure.
Just in response, the motion that Mr. Patterson filed is most related to the attorney that handled the pre-indictment. He did make an allegation that I failed to file his speedy trial motion. That's obviously been filed because he's got a speedy trial date.
right.
As far as his discovery goes, that was provided to him. He did request an audio recording of the preliminary examination. I contacted the court reporter who said that did not exist. It is destroyed once there is a transcript. He did request video from a Vivint camera at the residence. Again, by the time I get the case, that exists only for 14 days. By the time I have the case, that video no longer existed. And I believe the third thing he requested is to listen to his jail calls, which he made. I didn't provide transcripts of a call to him. However, the only thing we can do, because we can't provide a thumb drive to the inmate, is my investigator have to go sit there for 20 hours for him to listen to the calls that he was on. Aside from that, I have filed motions. I have filed his speedy. I've gone over his discovery. The issues he has relate to factual issues, which are trial issues. However, if he is, you know, if he's not comfortable proceeding with me, I have no problem, you know, withdrawing from the case, but I don't know. I think he would have to hire an attorney at this point.
Hey, ma'am, the calls he's saying that's 20 hours long, that's not true. There was only like 7 calls, and we probably spoke for like, what, 3-4 minutes? So if you combine them all, it's probably like about an hour at most. And he couldn't even let me listen to those calls.
But you were on those calls, so.
I am on those calls, and there's certain things I want to point out because I already done filed to the district court on habeas corpus on perjury. They got a lot of things. You can't lie about one thing and tell the truth about another. It does not work that way. So there's a whole lot of stuff in there, like the recording that she had for us, the audio. You know what I'm saying? She said that we in a preliminary hearing, she stated that there was some I asked her about having sex that night, and she said that she couldn't. But then when the recording starts, it's talking about something else. She perjured in there.
Advise not to
Yeah.
go forward with any facts regarding
I'm-
the case.
because
It's
what
all
you're-
factual. I'm saying I'm here for something that I didn't
It can be
do.
used against you. So here's the thing, when it's an appointed attorney, you can't really fire him. So, I mean, you can, but then they're not gonna appoint you another public defender. You got the money to hire somebody?
No, I ain't got the money to hire nobody, but if he ain't, I'm saying I'm being forced to trial with a lawyer that's not working for me. He's not doing none of the things he's supposed to be doing.
Did you not listen to what he said?
I
Video
heard
is
what he
not
said.
available?
What he said is not true, ma'am.
Just because you say it's not?
No, because I'm saying everything that I've been asking him to bring to me so we can go across it. He don't even have a defense for trial. That's in 10 days from now. He don't even have a defense for trial. Nothing. There's and all these charges. The gun just now getting handled. The gun should have been handled a long time ago when he looked at the search warrant and seen that it wasn't specified in the warrant. He should have been took care of that. Why we get to this point 9 months down the road, we just speaking on the gun. Where's the DNA evidence? Did we ever got that back? We just keep moving off of accusations.
They don't have to turn it over to
These
you.
are all factual issues, Your Honor.
Right, these are all, yeah, definitely. They're,
Legal issues.
I'm saying, but he's not doing his job.
well, I mean,
I'm having irreconcilable differences, ma'am. I stated a claim for which relief could be granted. I'm asking the court to remove this counsel from me, please.
anything from the state.
Nothing from the state, Your Honor, if you find that, if you grant his motion, Your Honor, the state just asked that there is a speedy filed in this case, if it can be withdrawn and he move forward pro se, if he wishes.
That's being forced to. I have never waived having an attorney. I just said I want this attorney.
Okay, but you can't fire somebody who's appointed to represent, you can't just keep firing them and going through.
This the first, no,
But I tell you what,
the first lawyer I had on this case, the other one was for preliminary. She withdrew on her own. I never fired her.
because
It-
she's, her, what she does is preliminary hearings.
Exactly. So I
Here you go.
never
I tell you
fired
what,
anybody else.
Stan, what I'm gonna do is I'm gonna grant you that divorce since y'all have irreconcilable differences, but
Mhm.
I'm not gonna remove him as your lawyer. Everything he said makes exact sense. They only have recordings for so long. And he's doing his job, and the state doesn't have to turn over discovery as of yet, probably. So there's timeline. So you need to, all right. So no, I'm not gonna remove him
Okay,
from.
my last argument is this here. The victim said I didn't stay at the house. I have a vivid security home system that he can
Okay.
use by my social security number prove that I've lived there.
Okay, listen to me. What you're saying now,
Mhm.
they're gonna get a transcript of this and use it in court against you.
Okay.
So when that person gets up there and says something different,
Mhm.
no, let Mr. Norman do his job. I promise you, he can do a much better job representing himself, you than you representing yourself.
I never asked to represent myself, ma'am.
That's your only choice. Hire somebody to represent yourself.
I just let the bar association just deal with it. I just make this complaint with them. It's gonna be an appellate issue. I'm letting the record reflect that I've spoken to you about it already. I stated the claim for which relief could be granted. You still refuse the motions. I done district court, everything. I keep saying this man is ineffective to me. And I have, under my Sixth Amendment right, I have a right to an effective counsel. And you keep saying, just stay with it. And I already know he's not working in my best interest. He's working more in the district attorney interest than anybody.
Okay, so Mr. Norman's your lawyer, unless he just, he finds some reason he wants to withdraw. He's doing everything he's supposed to do.
Mhm.
Sometimes things don't move at the pace you want it to. Okay, next.
Uh-huh.
So who's gonna send me the orders?
I can, I'll prepare this.
Okay, thank you. And so you'll.
No more comments. Get out of the courtroom before you're talking.
That Friday before.